So we can get started. Thank you everyone for joining us. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So, whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month on a vast variety of topics. And at the end of this webinar, we will be sending out a few things for the benefit of all participants. So first, we will send you a copy of this PowerPoint that will be used in this webinar. We'll also be sending you a guide, a comprehensive guide to the visa categories that will be discussed in this webinar that you can use as a resource. We will also send you a link that you can follow to sign up for any of the additional webinars that are coming up in the future, and also a link to access this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button to the channel, as we regularly do upload a variety of immigration law related videos that can be helpful to you. Finally, we will also send you a link that you can follow to set up a consultation with one of our experienced attorneys, should you wish to discuss your case in further detail. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let's get started. I will turn it over to Kelly.
Thank you. All right, so we're going to get started by talking about the extraordinary ability visa categories, both kind of temporary and the more permanent green card category. So what are the extraordinary ability visa categories? For the temporary visas, we have the O1A and the O1B. And so the O1A visa is for individuals with extraordinary ability in the sciences, education, business, or athletics. And there's a very high standard. You need to prove that you are someone who has risen to the very top of the field in your profession. For the O1B, this is focused on the arts and also on extraordinary achievement in the motion picture or television industry. And there's slightly different standards here. So for the arts, the person has to have achieved distinction, which is a high level of achievement, as evidenced by a degree of skill and recognition substantially above that ordinarily encountered in your field, or the standard for motion picture and television industry. This is slightly higher. You have to show you've reached a level of acclaim substantially above that of your peers. So for both of these, we'll talk a little bit more about them later in the presentation, but again, important things to know is that they are temporary visas. So if you do get this visa, it's really for you coming to the United States to work in your area of extraordinary ability for a temporary period of time, and then you would depart the United States. So this isn't for people that want to kind of live and work in the United States permanently, but it can be a step to that if you want to kind of enter the U.S. and see if you enjoy working here. And then potentially move to one of the green card options that we'll talk about in the next slide. All right, so these are the extraordinary ability categories for the green card. The EB1A green card is the green card that's available for people of extraordinary ability. We also have listed here the EB2 National Interest Waiver, and Jiyae will talk a little bit more about that later in the presentation, but I'm going to talk about why we've listed it here as well. So for the EB1A green card, when people are on an O1 visa, often this is the first green card they're thinking about. Like this is it combines sciences, education, business, athletics, and the arts. So for the O1A and O1B, they're separate. It's a little bit easier to get kind of the O1B for arts. It has a slightly lower standard of distinction. This isn't the case for the EB1A. For the EB1A, that it has the higher standard of showing your someone of a small percentage who's risen to the very top of your field, show sustained national or international acclaim, and that your achievements have been recognized in your field of expertise. So this is a very high standard. And just because you have an O1A visa, even though the kind of regulatory language mimics, the O1A and the EB1A, just because you have an O1A doesn't mean you automatically will qualify for the EB1A. It's a good start usually, but it is important to kind of talk to your attorney to understand, whether or not there is a strong EB1A case, and not just to assume that because you have an O1A, it will be a rubber stamp. And then this is particularly the case in the O1B context, where you can be granted an O1B based on distinction. And so when you're making that jump to EB1A, it's even larger than the jump from kind of the O1A to the EB1A. So all things to keep in mind if you are interested in kind of getting a green card down the road. So for example, if you're on an O1B or an O1A and maybe it was a very difficult approval, maybe you got a really tough request for evidence, you want to be thinking about, how can you be building up your resume? How can you continue to add to your list of achievements? If the EB1A is on your radar and something you want in the future, you can work towards getting your profile such that it would make for a stronger case, particularly while you're on the O1. But those are things to keep in mind, that some people believe that, well, if I get an O1, there's going to be an automatic pathway to a green card through the EB1A, and that's not the case. You do have to, prove you meet the standard, and because it is a green card, they do adjudicate them more, strictly. So the EB2 National Interest Waiver. So this is a green card category. So people who want to live and work in the U.S. permanently. It's listed here because sometimes it can be a good option for people that maybe are not quite at the EB1A level, but perhaps their work and what they actually are working on, has substantial merit and national importance to the U.S. Perhaps they have a very impressive background, but maybe not quite at the EB1A level yet. Because for the EB2 National Interest Waiver, a lot of the focus is on what is the individual doing in the United States. So if you have a very impressive project or something that has, substantial merit and national importance to the US, and then your background is impressive, but maybe not quite at the EB1A level, this can sometimes make for a really good national interest waiver case. And, for this, you show that, again, Jiyae will go over it in much more detail later in the presentation, but your proposed endeavor is kind of the key piece of this. And then, of course, your background needs to match that. There needs to be, a realistic nexus, to show that you have the ability to advance this endeavor. But it can be a good option for people maybe who are very successful in their field, working in really important areas, but maybe haven't quite achieved that EB1A, level of acclaim as an individual. So we can move on to the next slide. All right, let's talk a little bit more about the O1A. So the way that this works is you need to demonstrate that you have either received a major internationally recognized award, such as a Nobel Prize or a Pulitzer Prize, or much more commonly, people will, apply based on showing they have met, at least three of the following criteria. And so they're listed here. You can see there are things that kind of naturally would come up in your career. So receipt of nationally or internationally recognized prizes or awards, membership in associations which require outstanding achievements, original, contributions of major significance in your field. So you need to meet at least three, but obviously the more that you can meet, the better it is, for your case. That being said, you do want to think about quality over quantity. So for example, membership in associations in your field, which require outstanding achievements of their members. There's many professional industries where, for example, if you're a lawyer, you're a member of the bar, you can join any, state bar organization by paying a fee and proving that you have passed the bar exam. That's not going to be a good type of evidence for the O1A. What you would want to have is kind of an organization that actually has some very, strict requirements of their members, that shows they have outstanding achievements. So any type of organization or association where kind of you pay a fee and, you can join just based on being a member of a profession and having passed the basic licensing exam, that's not going to be good, for the O1A. So you do want to think about that when you're putting, your documentation together, including every single thing, like including student awards, like all of that can help, can kind of lower your profile in their eyes. And we'll talk about this a bit more later, but the way they adjudicate these cases is under, an analysis called the Kazarian analysis, where first they will look to see, have you met the plain language of the criteria? And then they're going to look to see holistically, when we put everything together, does it seem that this is someone who has risen to the very top of their field? And so if you're including things like student awards, basic, bar association, memberships, those are the types of things that actually can hurt you in the long run, because when they look holistically at your file, they'll feel, well, there wasn't enough there. So they kind of sent in things that really didn't meet the criteria. All right, let's look at the O1B requirements. So you'll see that the structure is very similar to the O1A, and that you either need to show, receipt of a major award or evidence of at least three of the following, and then the criteria are broken down on this slide and the next slide. As you'll see as you read through them, these are much more focused on what would make sense for the arts or for the motion picture and television industry. One thing to consider is that sometimes there's fields that don't neatly fit into O1A or O1B. Things like mixologists or tattoo artists. So there are some times where you have a little bit of license to be creative about which category you choose. Um, if you're in a situation where, your case is more borderline, often an O1B can be a better way to go if you do have some type of argument. But again, you need to look at the criteria and say, does it really make sense in light of the type of work I'm doing? Sometimes certain industries don't have they're not going to have the same types of metrics that, kind of were written into the regulations. I think the regulations even include like cassette tapes, like they were written a long time ago. So you do have to kind of be creative about what you're including. There is a category for kind of other comparable evidence, but it can be challenging to use that because you do have to show that the other criteria are not relevant to you. So all things to keep in mind when you're, kind of figuring out which route to go, O1A or O1B. And this is just the final list, yeah, of the O1B requirements. All right, we can switch back. So, in looking at the important differences, so we've talked about, their O1A is for science, education, business, or athletics. O1B is arts and motion picture, television industry. In terms of the standards, the O1A is going to have that higher standard of the small percentage of people who've risen to the very top of their field. And then, O1B is, a little bit easier. For the arts, it's distinction. And for motion picture and television industry, a level of acclaim substantially above that of your peers. In terms of how long these visas are issued for, they can be issued initially for up to 3 years. And then you can get extensions, in increments of 1 to 3 years. If you're just extending your initial set of projects, they're only going to approve it for 1 year. But let's say you have a new employer or you have a new set of projects, a new itinerary, you could potentially get a, kind of a longer approval for up to 3 years maximum. And these can be renewed. Indefinitely, as long as you still have, extra work in your area of extraordinary ability. It is important to note, though, particularly for kind of artists or people who are coming, let's say, you're coming for musical performances, and it only runs through a certain month, they won't grant you, an approval beyond the scope of your extraordinary ability work. So you do have to prove that work. And one thing they will do also is they like USCIS will look up, for example, during COVID, when there was a lot of cancellations of performances, some visas and some approvals, were reopened. USCIS came back and had questions because if they see that the performances are canceled, that is something that could impact whether or not, the visa will remain valid or the approval will remain valid. So you do want to keep that in mind when you're designing your itinerary. Sometimes you can add in other things besides just the performances to help support why you might need a longer stretch of time, but you do have to justify kind of the extraordinary ability work up to 3 years maximum. Can your family come to the US? Yes. So you can bring your spouse and any unmarried children under 21. They can attend school, both your spouse and children, but your spouse unfortunately cannot work, and your children cannot work either. All right, so let's talk a little bit more about the EB1A, extraordinary ability. So what are the requirements? They're listed here. It follows a similar, so it's not on this slide, but it follows a similar structure as the O1A in the sense that either it's a major internationally recognized award, or again, much more commonly, you're going to show that you meet at least three of the following criteria, and of course, more if you can prove more. You'll see that the language is slightly different because it encompasses both, arts and science education, business, athletics. Um, and so this would be kind of the criteria for the EB1A. And again, if you're going from an O1 to an EB1A, you don't want to just assume that you can take your O1 package and submit it for the EB1A. You're going to want to show, that you have continued to work in the area of extraordinary ability, that you've continued to, make progress in your field. And in fact, you also need to submit a statement that, demonstrates that you plan to continue working in your area of extraordinary ability. So the green card is not available for someone who says, I've had a really, illustrious career and now I want to retire. They do want evidence that you are going to continue to work in your field. And so you would need to kind of update your petition, to show you meet, this criteria. All right. So talking a little bit more about the, kind of the way they adjudicate these cases. And I mentioned this previously, there is something called the Kazarian analysis. This is relevant both to the temporary O1 and also to the EB1A. And so this is where you really want to be thoughtful about the, who you're getting to write the letters, who you're getting to, kind of vouch for your petition. Because even if you meet the plain language of the criteria, okay, you've submitted evidence for, three or four, and you claim that you meet this standard, they're going to look at everything holistically. They're going to look you up, particularly if you're in a niche field or a field where there's not kind of very traditional markers of success, where maybe if someone Googles you, you're not really going to come up because in your industry, that's not the way it is. And people are not really at the, kind of very public. That's something that you really need to think about strategically and explain to the officer because they are not going to have an understanding of your industry and you can't assume they will. It's really on you. As the applicant, and together with your attorney, of course, to, craft a compelling application that explains here's why this person it has someone who's risen to the very top of their field, even though their face isn't on a lot of news articles, or if there's been a really successful project, their name isn't in the newspaper about it because this is the way this industry works, and that's really on you to explain to the officer. So you do want to keep that in mind, particularly if you're in an industry that is very technical, that's very hard to understand. You can never assume the officer will just understand it. It is on you to explain it to them, and you want them to leave your case with that impression of, okay, this is somebody who's really accomplished a lot. That's what you want to leave them with because that's that second step of the Kazarian analysis where they're going to, take that impression that they've gotten and say, okay, based on the evidence we've received, is this someone who really is at the very top of their field? All right, so we're
All right.
moving on to the National Interest Waiver, and Jiyae will take us through that.
Thank you, Kelly. All right, so let's now talk a little bit about the EB2 NIW, which can be an alternative pathway to a green card, and can have, some overlap with some of the candidates who typically apply for an EB1A or the O1 visa. So the eligibility for the EB2 NIW, there are two aspects to that. So the first aspect is, do you meet the EB2 threshold requirement? So in order to meet the EB2 threshold requirement, and this is really the minimum requirement to meet even before trying to argue the national interest waiver, and applies to both employer-sponsored and NIW petitions. The way to meet the EB2 threshold is through two ways. Either you can show that you have an advanced degree, which is defined as a master's degree or higher, and this includes things like an MBA, for example, a PhD, a JD, an MD, something that requires you to already have a bachelor's before you start a program like that. So showing that you have an advanced degree, you can qualify through that. Or if you don't have a master's degree or above, you can also qualify as the equivalent of an advanced degree holder if you have a bachelor's degree in your field, plus 5 years of progressive work experience in your area after you have obtained your bachelor's. And progressive work experience is important here to stress. What they mean by progressive is that your work experience did not stay the same throughout the 5 years, but your the complexity of your duties and your responsibilities increased in seniority and level as you went through this progressive step in your career, and they would ask for evidence, detailed evidence of those this evolution in your job duties through detailed employment confirmation letters from your previous employers if you are arguing bachelor's plus 5 years. So if you don't have, either, the bachelor's plus five, or if you don't have the master's degree, there is another way you can qualify for the EB2 threshold requirement, which is by showing exceptional ability in the sciences, arts, or business. And how do you show exceptional ability? Now, one thing to note is that exceptional ability is definitely a much lower standard than the extraordinary ability standard that we have been discussing in previous slides. Exceptional ability is defined as a degree of expertise that is significantly above what is ordinarily encountered. So that you can see that the plain language itself is a little bit more lenient than, requiring you to be the small percentage that have risen to the very top of your field. So in order to prove exceptional ability, you need to be able to show at least 3 out of the 7 criteria that is listed here. And that includes things like, any diploma or degree related to your field. Um, if you have 10 years of full-time experience in your field, you can also use that. A license to practice your profession, evidence that you have commanded a high salary. And importantly, what you can also collect is evidence of recognition for your contributions to your industry or to your field. And this can be, supported by a wide variety of evidence. For example, you can get expert letters from relevant professional associations, government entities, or other relevant stakeholders in your field describing what were those significant contributions. You can also provide corroborating evidence of those significant achievements in forms like, if you've developed new technology, a copy of a patent that you publish, for example, that can be one example, or, a award or something that you have received from the industry for something that you've done that is, considered trailblazing, or, otherwise a significant contribution in your field. Um, Membership in professional associations can also be relevant evidence. It is important to note, though, that not only do you need to show that you meet at least 3 out of these criteria, the totality of the evidence here must also tend to show, when taken together, that you are someone who is indeed operating at a level that is significantly above what is ordinarily encountered in the field. So the quality of the evidence is also important, as well as meeting the plain language of the evidentiary criteria here. So now then, the other step of applying for an EB2 NIW is demonstrating that your case actually qualifies for a national interest waiver. So here, maybe it's helpful to describe what the national interest waiver is waiving. So the NIW is waiving what is called the labor certification and job offer requirement, which is, the requirement that all U.S. sponsors must go through before, offering a green card to a foreign national. But if you are an applicant and if you qualify for an EB2 NIW, then you don't need to get a U.S. job offer from a U.S. company, and you don't need the U.S. company to go through the labor certification process, which is a process by which they search the labor pool, the U.S. labor pool, to see if there is a U.S. citizen who can take your job, who is also minimally qualified, and only if they can show that there is no other person available, then the company is allowed to sponsor the foreign national for the green card. But if your case qualifies for an EB-2NIW, then you don't need to show that. You don't need to have the job offer. You don't need to have a U.S. sponsor. So then what kind of cases then can qualify for an EB-2NIW? So the relevant three-prong test is called the matter of Denisar three-prong test, and there are three different aspects to that. So the first one is, can you prove that your proposed endeavor has both substantial merit and national importance? Now, the proposed endeavor is kind of like a plan that you submit to the US government, and it must be more than just proposing to work in your field, right? Because they're looking for someone who's proposing to do something more. So are you, you know, driving forward a new project that will, improve treatment options for a particular disease, for example, if you're a medical researcher? Are you developing a new technology that will make manufacturing, easier and more efficient for a particular type of semiconductor product, for example? So they're looking for a more specific and qualitative plan on what you intend to do in your field, as opposed to just saying that you are going to work in your field, as an engineer or, as a lawyer or something like that. So it goes one step further than just working in a profession. Now, the requirement is that the proposed endeavor should have both substantial merit and national importance. So, substantial merit and national importance can be shown in a wide variety of fields, including things like business, health, education, science, and technology. And you can include endeavors such as, things that will further human knowledge in certain key areas, technology or science. And some of the examples that the case law talks about are things like medical advances and improvements in civil engineering processes, things like that. And if you can show that your proposed endeavor in the United States could have a very large scale positive economic impact to a particular field or to the nation more broadly, that can be very helpful in meeting the national importance criteria. So really, the question that you want to ask here is, what is the impact of my work in the United States? And can I show that the impact of my work will go beyond just benefiting my immediate employer or just benefiting the clients who use my services, but improving the field in some way, or otherwise providing a large scale benefit to the public interest in some way. In various fields. So those kinds of arguments can be supported by evidence such as expert letters from people in your field who is active in the United States, who can provide their opinion on what is the prospective impact of your work. Government pronouncements and declarations can be helpful. Now, there needs to be a strong link to your specific endeavor, though. So, government pronouncements saying things like, oh, AI is important to the United States, and then your endeavor is just going to say, oh, I'm going to work as an AI engineer. That kind of loose connection may not be enough. You really want to make a stronger link to your specific proposed endeavor. And the more specific a piece of evidence is to your proposed endeavor, the more persuasive it will be for supporting your case. The second prong is that you are well positioned to advance the proposed endeavor. So here, the inquiry is on the individual themselves. So the USCIS will look at things like the person's education and experience, a track record of success in the industry, and record of kind of a portfolio of previous projects that they've done that is related to the proposed endeavor that, may persuasively tell the officer that you are indeed someone who can successfully drive forward that kind of project. Those previous experiences will be relevant here in proving that you're well positioned to advance the proposed endeavor. Intellectual property, for example, if you're someone who develops technology and you've developed new technology that has been published in patents, or if you've announced your discoveries in conferences, or if you've written journal articles about a particular technology that you've developed, things like that, showing dissemination of your original insights to others in your field, that can definitely be helpful in showing that you have a track record of influencing your field, which could help prove this prong. And here I think there can be some synergy with, O1A or EB1A candidates who may have, already have accumulated this history of influence in their fields. So there can definitely be some overlap in the evidence that you can use to support well-positioned. Finally, the third requirement is that there must be a showing that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. So what you can do here is to perhaps stress the broad positive impact your work can have to, advancing a technology that is important to the United States, for example, or to public health, for example, if you're working on developing a new drug for a disease. If you are successful in that endeavor, many lives will be saved, and that can definitely be a huge benefit that overrides the ordinary benefits of a labor certification and job offer requirement to protect the labor supply of the United States. Or if you're an entrepreneur, for example, and if you are creating a very, very high number of jobs in an economically depressed region, for example, that could in itself also be a compelling benefit that would outweigh the ordinary benefits of saving one job for a U.S. person for that particular position. So there are many different ways you can argue the on balance prong, but really it is important to make sure that you have the first prong and second prong really stably set in stone, so that you can use those kinds of evidences to also argue the third prong. All right. So let's shift gears a little bit and talk about expert opinion letters, which tend to be a very important building block for the EB1, O1, and NIW petitions. So what is included in the expert opinion letters? So one thing you want to talk about before even talking about the content of the expert letters is who is writing the letter. So you really want to try and get letters from key individuals in the industry, not necessarily people who are your juniors, but people who are recognized as leaders in the industry with typically decades of experience in the field. And it is very common to add the full curriculum vitae, the full length resume of the people who are writing the letter, to submit with the letter to ensure that the government can see that those people do have the authority and knowledge to speak regarding the caliber of your work, if you're, doing the EB1 or O1, or the prospective impact of your work in the United States, if you're doing the EB2 NIW, for example, to support national importance. And you can also get letters. We would so different letters play different roles, and so um, we tend to talk about, different sources of letters, inner circle letters and independent letters. So inner circle letters are people who you have worked with before. And those types of experts can speak in great detail about your past achievements and the past projects that you have done, and really also to the impact that your past projects have had in the industry or field more broadly. So past employers, for example, colleagues, people that you have conducted projects with can provide that kind of letter, providing that detailed perspective of what you have done in the past. Um, Other types of experts are called independent experts, and independent experts are people who have not directly worked with you before, but they know you through your work or through your reputation in the industry. And those types of letters can be valuable because USCIS may tend to think that these letters bring a more objective view of the caliber of your work in the field if they haven't, directly worked with you in the past. So those kinds of expert letters can confirm that your abilities are indeed outstanding in your field, or that your work stands to impact the field. And we would say it is important to try and get letters from both inner circle and independent experts, because they do play different roles. Now, discussion of your work. So, what is the content that we recommend that the expert letters contain? So, specificity is very important in when we're developing expert letters. The expert letters should discuss your work in detail, and also a discussion of why your work was important, or why does your work set you apart from others in your industry. Really, those detailed arguments can really make or break a case because it really brings out the narrative to the USCIS officer to understand, who may not really be familiar with your industry. But if you give them, if you paint a compelling picture of, for example, what was the field struggling with regards to a limitation on a particular, technology or a particular, medical treatment, and let's say you came in and provided a new solution to that, problem the industry was facing. If you paint a story like that, you can really, this can really go a far way to convince the officer that your work was indeed outstanding, setting you apart from the vast majority of other professionals in the field, which is what the extraordinary ability visas really are looking for. So that's why specificity in the letters can be very helpful in supporting a compelling O1, EB1, or NIW case. All right. So now let's talk a little bit about some strategic questions. When you're deciding which category among these options would you apply for, there are a couple of questions you may want to ask. So the first inquiry is, do you want to stay in the United States temporarily or permanently? So as Kelly mentioned in the previous slides, the O1A and O1B are non-immigrant visas that is well suited for, a temporary stay in the United States tied to a particular event, a particular engagement that you're coming in to do, and your intent is, to leave the United States after those events are completed. Now, it is important to note that if you continue to have extraordinary ability caliber work in your field in the United States, you can apply to extend and renew the O1 visas as long as you, continue to meet those criteria, and as long as, the work is there. There is really no lifetime limit to how many times you can renew the O. But but generally speaking, the O visa is definitely well suited for people who, want to come to the United States on a temporary basis. The EB1A and NIW, they are both green card categories, which is well suited for people who plan to live in the United States permanently. And it is important to note that because becoming a green card holder also comes with responsibilities. So, for example, there's a limitation on how long you can stay outside the United States as a green card holder. So, definitely, it is a matter of what you personally plan for to be, the main stage of your life. Where do you want to spend most of the time? So it can really make the difference on what category you may want to apply for. The other question to ask is, do you have a U.S. employer or agent, or do you want to self-petition? So the O1 requires a U.S. petitioner. Now, the petitioner can be a U.S. employer, the entity that will require your services, or the O1 petition can be filed through a U.S. agent, and that agent will be the one who will, coordinate the contracts with other U.S. entities that will be using your services. Now, one thing to note though is that if you are an entrepreneur and you are interested in coming to the United States on an O1 visa, one option that may be available to you is that if you set up a U.S. business, a U.S. entity, a legal corporation or LLC, for example, in the United States, that U.S. entity is considered to be a separate entity than yourself, who is a foreign national. So that U.S. business that you set up can be the U.S. petitioner for the O1 purposes. Now, one thing to note, though, is that there must still be a bona fide U.S. Job offer, which means there must be some evidence of work existing in the United States for, your entity, if that's, the entity, if the entity is employing you, for example. So there must be some more evidence than just having the entity set up. But definitely reach out to us. We can definitely provide more information about, what kinds of evidence you may be able to submit to meet that requirement. Now, by contrast, the EB1A and NIW are both green card options that allow the foreign national beneficiary to self-petition. That means you don't need to have any, U.S. connection in terms of driving forward the petition to file the green card application. You can even do this from abroad. So if you may have a little bit more freedom on, self-petitioning if you're looking at the EB1A and NIW categories. Now, then the final question, let's talk a little bit about family considerations. For the ONA and OMB, your spouse and children under 21 can join you in the United States on an O3 dependent visa. However, there is no work authorization available for the O3 category, which means your spouse and children can study in the United States while you're here, but they cannot work. Now, by contrast, the EB1 and NIW, they're both green card options, and your spouse and children under 21 can also apply for green cards as dependents and get the same benefits that you would have as green card holder. And if you are applying for the green card in the United States by filing an I-485 adjustment of status application, you're able to also apply for work authorization and travel authorization when you file the I-485. The same benefits also apply for your spouse and children as well when they apply for their own I-485s based on, your approval as dependents. So that can be a significant advantage for some circumstances. All right. So let's talk a little bit more about the strategic considerations. When you are moving from a non-immigrant visa to a green card. So a non-immigrant visa, as we mentioned, the O1 is a non-immigrant visa suited for, people who want to work temporarily in the United States. A green card is a permanent residency status. So what should you think about when you're thinking of moving from a non-immigrant visa to a green card? The first question to ask is about qualifications. So, and this has been discussed in previous slides by Kelly, but there is a higher standard for extraordinary ability to qualify for an EB1A green card, as opposed to the O1A or OMB, even though the regulatory language is very similar on a practical level, and also because of the Kazarian case, EB1A adjudications are very strict. They're really looking for people who have reached the very, very top of their field and those who can provide a volume of compelling and high quality evidence that tends to show that they have reached that status. So qualifying for an ONA or OMB does not mean you automatically qualify for an EB1A, even though the regulatory language is similar. The way the standard is adjudicated is very different. Timing. So definitely consider how much time is left on your current underlying visa before filing, an EB1A petition or an NIW petition, because both are immigrant petitions. And the reason why is because some visas are harder to extend or subject to more scrutiny once I-140 is filed. So a good example is the TN visa, for example. The TN visa really looks into non-immigrant intent, which means when you're coming in, you're basically telling the U.S. government that your intent is to work temporarily in the United States. You're not interested in, adjusting your status later to become a green card holder. But if you have filed an EB2 NIW petition, or if you have filed an EB1A I-140 petition, that can be, seen as one step towards permanent residency, and it can complicate, your ability to renew or apply for a new visa in certain categories, where the government is a little bit more sensitive to that. So definitely talk to an attorney to discuss what may be, the optimal timing of things, and to plan ahead when you're thinking of applying for any of these categories. Finally, family considerations may also inform which strategy to take. So, if you have children, for example, who may also need the green card, you can consider filing for the EB1A or NIW green card option early to avoid issues with the children aging out at 21. All right. So the final question we will go over before going to the Q&A is, are extraordinary ability categories available for entrepreneurs? And the answer to that question is definitely yes. So let's talk about a few points regarding that. So the EB1A and NIW both allow for self-petitions, meaning that both are possible options for entrepreneurs. So you do not need a U.S. job offer. You do not need a U.S. company to sponsor your petition if you're going through the EB1A or NIW pathway. So entrepreneurs can definitely take advantage of that. Changes in the NIW standard under a matter of Danisar, which is case law from 2016. It made NIW a much friendlier category for entrepreneurs, and practically we actually have seen a lot more entrepreneur cases being filed and being used as a viable pathway for a green card under the EB2 NIW category. Finally, it is possible to apply for an O1A visa as an entrepreneur if there is a separate U.S. corporate entity that can serve as the U.S. petitioner to drive forward the petition. There can be complicated strategy issues regarding using that kind of approach, so definitely reach out to us if you'd like to discuss your case in further detail. All right, so let's see if we have any questions. Okay.
Looks like there's one.
All right.
How many job offers are ideal to have on the itinerary for the O1B? Gia, do you want to talk about this?
Yeah, sure. Um, so really there's no minimum number of a job offer. So it can be an event that, goes on for a period of time with, one particular company, or it can be a collection of many different engagements that you may have in the United States. Maybe in that case, you will use an agent to file. So yeah, we have definitely seen, O1 cases where there was only one, quote unquote job offer or job opportunity. So there is no minimum number as long as you have at least one. All right. So it looks like we have answered all questions. Thank you everyone for your participation. Thank you, Kelly, for sharing your expertise. And we will close here. Thank you.
Thank you.